So can football players and other athletes claim damages for what they perceive to be the misuse of their personal data rights? Hello, I'm Dominic Walker. Welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel, like this video, and keep the conversation going in the comments section. So my guest is Lucy Marlow. Lucy is a senior associate solicitor within JMW's intellectual property department. Lucy has an interest in sports law. So Lucy, let me start off by asking, what is Project Red Card?
Project Red Card is a legal claim that's been spearheaded by Russell Slade on behalf of lots of athletes, especially footballers, claiming compensation for the alleged misuse of their personal data and private information.
And just playing devil's advocate, if I may, just for a moment or two, I work closely with football players, with rugby players and other athletes. I've seen the little GPS tracker and the laptops that monitor that as well. Aren't clubs entitled to use player data?
Well, here, because we're talking about personal data and private information, really express consent should be given by the athletes. Now, in the case, for example, of sports clubs, there's a legitimate interest in gathering that data from a sports performance perspective. So if you're able to understand how fast an athlete moves, their heart rate, etc., that how many successful passes they're making, then that data can be used to inform performance, manage injuries. So there's a legitimate interest for clubs in gathering that data. Where we stray into the territory which this claim concerns is when that information is sold on to other third-party companies like betting companies, gaming companies, and they're using that data and making lots of money out of it. And ultimately, the athletes themselves aren't receiving a slice of the pie.
So in these kinds of cases, Lucy, how is damages calculated?
So damages would be awarded by way of user damages. And what the court would do here is it would assess what fee a reasonable person would be willing to pay to use the personal data in question. And then that fee is what would be used to inform the level of damages. So in other words, what would the betting companies and the gaming companies have paid the footballers in order to have used their personal data? And it's quite clear that given that a lot of these professional athletes are very well versed in commercializing their assets, that they are likely to be able to demand quite a substantial sum when looking towards the calculation of the level of damages.
And there may be people watching this video at the moment, Lucy, scratching their head thinking, well, hang on a minute, is there a blurred line between your speciality of intellectual property and data rights?
Well, exactly. And I think that's probably a position which maybe some clubs have fallen into, where there's an understanding that perhaps their image rights agreements covers this type of data, and that under those agreements, they're granted the rights to use this data. Now, what I would be saying is that it's really important to go back to those agreements and have a look as to exactly what rights are granted under the agreements. And, you know, going forward, when entering into new agreements, it's worth addressing this point at the outset in order to avoid being in a position where perhaps there's litigation in the future.
Thanks for your insight, Lucy. And if you'd like to speak to Lucy and the sports law team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.